The rights or protection of employees with respect to the termination and layoff is the rights of employees to be given a due notice of termination of contract based on the Section 12 of the Employment Act 1955. So the notice must be stated the intention for the termination and its justification by the employer. The length of such notice must be given less than 4 weeks for the employees that works for 2 years and not less than 6 weeks notice for the employees works 2 years or more but less than 5 years, and 8-week notice for the employees works 5 years or more. Next, the protection of employees to have the layoff benefits based on the Section 60J of the Employment Act 1955, which the employee provided layoff benefit referred with the Employment Termination and Layoff Benefits Regulations 1980. So the benefits based on Regulation 6 is the 10 days wages of every year of employment with 2 years of services, 15 days of wages for every year of employment of more than 2 but less than 5 years, and then the 20 days of wages for every year of employment with more than 5 years of services.
For the first question, I will talk about the termination. Termination of employment can be described as the time when the employer and the employee relationship between the employee and the organization are being terminated for cause or without a reason. This means that the termination of employment is involuntary and also voluntary when the employee leaves the organization on their own. There are some rights and protection that being provided to the employee with the respect of termination layoff, which is in the Employment 1955, the employee should be entitled for the termination benefit payment where his contract of service is terminated for any reason without whatsoever. However, there are some cases that makes the employee unable to be entitled for it, such as the employee attaining the age of retirement and the employer terminate the employee on the ground of misconduct inconsistency and the employee voluntarily terminate their own contract.
Moving on to question number 2, the question asks whether Mr. Bala has contravened any provision of the Employment Act 1955. Yes, Mr. Bala has contravened the provision of Employment Act 1955 when he terminates services of Haris, Siva and others 48 employees, and then he replaced them with Indonesia employee, which is foreign workers. Under Employment Act 1955, Section 60M stated that no employers shall terminate the contract of service of a local employee for the purpose of employing a foreign employee. As we can see, Mr. Bala has contravened the Employment Act when he replaced local employee with Indonesia employee. Next is question number 3. The question asks to give a protection that available to Indonesian workers at the company. To be clear, foreign employees are entitled to a protection provided in Employment Act 1955. Therefore, the first protection is a payment of wages. Under Section 19(1), an employer must pay the employee within 7 days after the last day of wage period. As a result, Indonesian employees at Nippon Denso Sdn Bhd have their wages protected.
Assalamualaikum, my name is Nurali Barha and I'm going to continue answering question 3, which is the protection available to the Indonesian workers. The first one is working hours. The rules and regulations for working hours in Malaysia pursuant to Section 60A Employment Act 1995 are a maximum of 8 hours per day that based on a 6-day working week, or maximum 9 hours in 1 day that based on a 5-day working week, 6 working days a week, which accumulated work week to 48 hours. If the Indonesian workers of Nippon Denso Sdn Bhd agree to work for more than normal working hours, they shall be paid in accordance with the labor laws. Foreign employees shall not work for more than 5 hours consecutively without a minimum rest time for 30 minutes, which the employees shall have the opportunity to eat as provided in the Act. The second one is leave entitlement, which are annual leave and medical leave. Section 60E of Employment Act 1955 stated that the foreign workers that have been working for less than 2 years are entitled to get 8 days of annual leave. More than 2 but less than 5 years get 12 days. 5 years and above are entitled to get 16 days. However, the employer has the right to reject any application if it is not suitable to take leave at that time. Section 60F of Employment Act 1955 stated that the foreign workers' duration of service that less than 2 years are entitled to get 14 days of medical leave, more than 2 but less than 5 years get 18 days, 5 years and above 22 days, and if the worker suffer illness that is serious and requires hospitalization, the workers receive 60 days of paid medical leave in total, notwithstanding the period of employment. Therefore, the foreign workers of Nippon Denso Sdn Bhd are applicable for annual leave and medical leave upon their request.
We are very familiar with the nature of relationship between employer and employee where they are being protected under Employment Act 1955 and Industrial Act 1967. Therefore, Siva and Haris can take a legal action against the employer with the issue that they were being terminated by file a complaint with Director General of Industrial Relations within the 60 days of being terminated. This is due to the unjust dismissal even though Mr. Bala has given notice. On the side note, the dismissal of misconduct should follow the procedure that will justify whether it is a due to inquiry or domestic inquiry, as what has been stated in Section 14(1)(a) of the Employment Act 1955. Right after they decide to file a complaint, they will organize a meeting between employer and employee to achieve an agreement. If Siva, Haris and their employer can come to a settlement, the case will be considered closed. However, if they happen to be not reaching a settlement, this issue is being referred to Minister of Human Resource to decide whether or not it should refer to Industrial Court for them to decide whether the employee's termination was lawful.